If you are facing federal drug conspiracy charges, there's a legal doctrine you need to understand because it could determine whether you spend the next decade or more in federal prison. It's called the Pinkerton liability, and it means you can be convicted and sentenced for crimes you did not commit, drug quantities you never touched, transactions you never witnessed, and violent acts committed by people you may have barely known. The only requirement is that the crime be reasonably foreseeable as a consequence of the conspiracy you joined. I'm Michael Lowe, a board-certified criminal defense attorney in Dallas. I have spent over 2 decades defending people against federal drug charges. Today, I'm going to give you a comprehensive breakdown of Pinkerton liability, where it comes from, how federal prosecutors use it against you, what they have to prove, and most importantly, how we fight back. Pinkerton liability comes from a 1946 Supreme Court case called Pinkerton versus United States. Walter and Daniel Pinkerton were brothers who conspired to evade taxes on illegal whiskey. Walter committed several substantive tax violations on his own. Daniel did not participate in those specific crimes. Daniel argued he could not be guilty of crimes he didn't personally commit. Here's what makes this case remarkable. Daniel Pinkerton was sitting in prison on unrelated charges when some of Walter's crimes happened. The conspiracy followed him through that cell door, but the Supreme Court said it doesn't matter. The court held that during the duration of a conspiracy, overt acts by any conspirator are attributed to all other conspirators. As the Department of Justice puts it, so long as the partnership in crime continues, partners act for each other in carrying it forward. An overt act of one partner becomes the act of all without any new agreement. The court upheld Daniel's conviction because he had not formally withdrawn from the conspiracy. This ruling created vicarious criminal liability as broad as civil liability of a business partner for acts done by a co-partner in the course of the firm's business. That rule is still the law today, and federal prosecutors use it aggressively in drug conspiracy cases under 21 USC 846. So how does a federal prosecutor apply Pinkerton liability to hold you responsible for someone else's crimes? There's a 4-element test. First, you were a party to the conspiracy. Second, the offense was within the scope of the unlawful project. Third, the offense was committed in furtherance of the conspiracy. And fourth, you could have reasonably foreseen the offense as a necessary or natural consequence of the unlawful agreement. That fourth element, reasonable foreseeability, is where this gets dangerous for drug defendants. Federal courts interpret reasonably foreseeable very broadly in drug cases. If you joined a drug distribution operation, violence is considered foreseeable because the drug trade involves disputes over territory, money, and product. Additional drug transactions beyond what you personally knew about are considered foreseeable because expanding distribution is a natural goal of a drug operation. Weapons possession is considered foreseeable because drug dealers often protect themselves and their product. This broad interpretation means that a person who joined a conspiracy in a minor capacity can be held responsible for murders, assaults, robberies, and massive drug quantities they never knew existed. Now, let me be clear about what the government has to prove to apply Pinkerton liability against you. First, prosecutors must establish that a conspiracy existed. This requires proof of an agreement between 2 or more people to violate federal drug laws. The agreement does not need to be written or even explicitly spoken. Courts allow prosecutors to prove agreements through circumstantial evidence such as coordinated conduct. Second, the government must prove that you knowingly joined the conspiracy. This means showing you knew the purpose of the agreement and voluntarily participated in it. Mere presence or association is not enough, but federal prosecutors can use evidence like phone records, text messages, and cooperating witness testimony to establish knowing participation. Third, the government must prove the substantive crime committed by your co-conspirators was reasonably foreseeable to you. This is where defense challenges often focus because the scope of foreseeability determines how far your liability extends. Courts have set limits on Pinkerton liability when substantive offenses were clearly outside the scope of the conspiracy or could not have been anticipated as a natural consequence. However, those limits rarely help defendants in drug conspiracy cases because federal courts generally presume that violence, additional drug transactions, and weapons are foreseeable in a drug trade. The consequences of Pinkerton liability extend far beyond the question of guilt. Let me explain what happens at sentencing. Under federal sentencing guidelines, your sentence is calculated based on the total drug quantity of the entire conspiracy during your period of involvement. You are not sentenced based on what you personally handled. You're sentenced based on what the operation moved while you were a member. Federal drug crimes carry mandatory minimum sentences that judges cannot reduce below statutory floors. A first offense involving 5 kilograms of cocaine triggers a 10-year mandatory minimum. 1 kilogram of heroin carries the same 10-year floor. If someone died from drugs connected to the conspiracy, the mandatory minimum jumps to 20 years. Beyond drug quantity, Pinkerton liability affects sentencing enhancements. If any co-conspirator possessed a firearm in connection with the conspiracy, you can receive a 2-level enhancement under the sentencing guidelines, even if you never saw the weapon. If violence occurred, the relevant conduct calculations can increase your offense level substantially. The practical effect is that someone who joined a conspiracy in a minor role can face decades in federal prison based on conduct by the people they barely knew. The Supreme Court in Pinkerton did recognize some limitations on vicarious liability. A different result would arise if the substantive offense committed by a co-conspirator was not done in furtherance of the conspiracy, did not fall within the scope of the unlawful project, or could not reasonably be foreseeable as a consequence. In practice, these limitations create potential defense arguments. If a co-conspirator committed a crime for purely personal reasons unrelated to the drug operation, that crime may fall outside the conspiracy's scope. If the criminal conduct was so bizarre or unpredictable that no reasonable person could have anticipated it, the foreseeability element may fail. If the crime occurred after you withdrew from the conspiracy, Pinkerton liability should not apply to that offense. But withdrawal is a critical concept and notoriously difficult to establish. Courts require affirmative action to defeat the purposes of the conspiracy or communication of withdrawal to co-conspirators. Simply stopping your participation is not enough. You must take steps that demonstrate your intent to abandon the criminal enterprise. And here's the hard truth. Even successful withdrawal only protects you from crimes committed after you withdrew. You remain liable for the conspiracy itself and for all substantive offenses that occurred while you were a member. I want to address something that confuses a lot of people. Pinkerton liability is not the same as aiding and abetting. They are distinct legal theories with different requirements. Aiding and abetting requires proof that you consciously shared in a criminal act by assisting another person. Pinkerton liability requires proof only that you were part of a conspiracy and that crimes were foreseeable to you. You can be convicted under Pinkerton liability without any direct assistance in the substantive crime. That makes Pinkerton broader in some respects than aiding and abetting, and it is why federal prosecutors love to use it. So how do we fight back? There are 5 main strategies I use to challenge Pinkerton liability in federal drug conspiracy cases. The first approach attacks the conspiracy itself. If the government cannot prove an agreement existed or cannot prove you knowingly joined it, Pinkerton liability cannot attach because there is no underlying conspiracy connecting you to co-conspirators' conduct. We examine the evidence of agreement carefully, looking for proof that conduct was merely parallel rather than coordinated. The second approach challenges the scope of the conspiracy. Large drug investigations often involve multiple separate conspiracies that prosecutors try to charge as a single conspiracy. Demonstrating that you are part of a smaller operation unconnected to other defendants can limit your exposure to drug quantities and drugs outside of your actual involvement. The third approach targets foreseeability itself. We argue that specific crimes fell outside of what any reasonable person would anticipate from the conspiracy you joined. This is particularly relevant for violent crimes that may have stemmed from personal disputes rather than drug business. The fourth approach involves withdrawal. If you took affirmative steps to abandon the conspiracy before certain crimes occurred, we present evidence of that withdrawal to limit your liability. The fifth approach focuses on sentencing mitigation, even when liability cannot be avoided. Minor role reductions, safety valve provisions, and cooperation agreements can significantly reduce sentences for defendants who played limited roles in the conspiracy. The safety valve in particular, can allow a judge to sentence you below the mandatory minimum if you meet certain criteria. If you are under investigation or facing charges for a federal drug conspiracy, here is what you need to do right now. First, exercise your right to remain silent. Anything you say to federal agents can establish your own knowledge of the conspiracy, your agreement to participate, and the scope of the activity you knew about. Each statement expands the potential reach of Pinkerton liability. Second, retain an experienced federal criminal defense attorney immediately. Federal drug conspiracies are among the most complex and serious charges in the federal system. You need an attorney who understands how federal prosecutors build these cases and how to challenge the evidence linking you to co-conspirators' conduct. Third, work with your attorney to analyze the scope of your actual involvement versus the scope the government is trying to attribute to you. Early investigation can identify evidence that limits your role, establishes withdrawal, or demonstrates that certain conduct was not foreseeable to you. Fourth, evaluate all options including trial defense, plea negotiation, and cooperation. Pinkerton liability creates enormous pressure on defendants because the exposure is so high. An experienced attorney can help you understand the realistic options and outcomes for your specific situation. Pinkerton liability makes federal drug conspiracy charges exceptionally dangerous because your fate is tied to the conduct of everyone else in the conspiracy, including people you may barely know. The potential for decades in federal prison based on crimes you did not commit demands aggressive, experienced legal defense from day one. I'm a former prosecutor who has tried more than 150 jury trials defending clients against serious federal charges throughout Texas. If you or someone you love is facing federal drug conspiracy charges, call my office at 214-526-1900 for a free consultation. The link is in the description below. Do not wait. The sooner we start building your defense, the better your chances.